Brianna. I'm gonna get it right. Okay. All right.
It's being live streamed.
Okay, thanks. Okay, we are officially live. It is 4:02 on Monday, March the 13th, 2023. And this is a meeting of the Public Safety Subcommittee for the House Judiciary Committee of the Maryland General Assembly. Welcome everyone who is here. We have 4 bills on our agenda for today. House Bill 758, House Bill 759, House Bill 582, and House Bill 663. And we'll take them in that order. So we'll first start with House Bill 758, which is from Delegate Bartlett. And I know we have a couple of folks coming in who are here for 758. So I'll let them come into the room, in the Zoom room here. And we also have an amendment to 758. Did all the committee members get a copy of the amendment? Yes. Okay, looks like that's the, no, Kim, you didn't get it? Okay. All right, well, we'll email a copy over to everyone again now. And then I know council's on the line. So Lauren, if you want to go over the bill and also the amendments and kind of what this bill now does, that would be great.
Okay, and I wasn't privy to the drafting of the amendment, so I can't give a lot of background. If Delegate Bartlett, I know she's invited, but I haven't seen her, but I can give an overview and then explain what I can see from the amendments. It's altering. Can you hear me also?
Yes, we can hear you. We can hear you.
I'm in the office, but it says my internet connection is unstable, so I'm not sure. Okay, the bill's altering requirements for the storage and preservation of sexual assault evidence kits. Significantly, it increases from 20 to 75 years the time after the collection of evidence during which a sexual assault evidence collection kit or other specified evidence cannot be destroyed or disposed of by a law enforcement agency unless specified criteria are met. The bill also adds with this, and this is the amendment, adds uncodified language providing for the retention and transferal of a sexual assault evidence collection kit collected before January 1, 2000 and stored by a hospital or child advocacy center, and requires the Maryland Sexual Assault Evidence Kit Policy and Funding Committee to issue a report regarding guidelines for transfer of the sexual assault on these of self-administered sexual assault evidence collection kits. And just going through the amendment, so that sort of is a summary of the bill with the amendments. And then going through each amendment, amendment number 1 is technical. Amendment number 2 alters definitions in the bill, removes references to healthcare providers and hospitals in certain provisions, and strikes language relating to sexual assault kits in the custody of persons other than law enforcement. And amendment number 3 is adding the uncodified language that I described earlier, providing for the retention and transferal of sexual assault evidence kits collected before January 1, 2000 and stored by a hospital or child advocacy center, and requiring the Maryland Sexual Assault Evidence Kit Policy and Funding Committee to issue a report regarding guidelines for the transfer of sexual assault evidence kits and guidelines on the use of self-administered sexual assault evidence kits. And that's basically the summary.
Okay. Are there any questions about I guess we'll start with the amendments. Are there any questions from any of the members of the committee? And we do have a couple of the advocates with us too. Folks have questions as well for any of them. Okay, we'll see none. I will entertain a motion to accept the amendments.
Motion to accept the amendments, Madam Chair.
Okay, thank you. Is there a sec? Oh, Conway, I see you have your hand up. Are you seconding, or you just have, or is this for discussion?
I have a discussion question.
Okay, let's get a second on this, and then we can go into discussion.
Okay, second.
Okay, all right, and then Delegate Conway.
Thank you very much. What how does that amendment deal with the self-administered?
Of course, they're not a very thoughtful gift device, so I bought a nice bottle here.
Delegate Pasteur might need you.
But Karen said, how about if she takes her?
Okay, Delegate Conway, you were asking how does the
How
amendment,
does the amendment deal with the self-administered sexual assault kits?
okay. I know we have a couple of advocates here. I see Lisa Jordan. I don't know if you want to take that question, Lisa, or Ms. Krinky, either one. I don't know if I pronounced that correct. Oh, okay. Okay.
Thank you, Chair Williams. What fun it is to say Chair Williams. So the do-it-yourself kits, as they're referred to, Delegate Conaway, are handled two ways. One is that law enforcement will be required to accept them and retain them, but that is so they can then be evaluated. So they're handled a little differently than the regular safe kits, which fall into they must be analyzed category. There's another layer of determination by the prosecutor's office about whether or not they're going to be tested. But then I think as importantly is that uncodified language that was described, and that will allow the SAKE committee, this bill is a product of the SAKE committee, the Sexual Assault Evidence Kit Funding and Policy Committee, to provide guidance about the do-it-yourself kits. And then also the Consumer Protection Division of the Office of the Attorney General will be required to kind of develop some sort of policy. There's a real concern that people are being misled about the do-it-yourself kits, and they think that this is going to produce something that will create evidence that can be analyzed. I think that's unlikely. On the other hand, for those of you who are familiar with fresh complaint evidence, where someone has evidence that they had a sexual assault, they just told someone, this does corroborate that something happened. It's unlikely someone would perform a do-it-yourself kit unless something had happened. So it's kind of trying to make sure we don't lose any evidence that has been collected and that we're going forward with some good policies.
Question, where's your data that says it's less likely that someone would say that or administer a self-test if nothing happened? Where do you get that from?
Well, I think that's an excellent question, Delegate. I don't know that there is any data. I do think that from I guess it's an experiential lived experience that, people generally don't insert things inside themselves to collect different samples unless there's a good reason. It's an uncomfortable thing. It's an invasive thing. So we think it's generally unlikely that someone would perform a do-it-yourself kit without reason, but that would be really up to the jury and first up to the prosecutor about whether or not that would be.
I'm not saying that it's without reason, but let's say a person is scorned. They might use that as a tool to get back at another person.
Exactly why the prosecutor would have to analyze it, and exactly why that sort of information would be presented to the jury. I mean, you're exactly right. Those are the sorts of questions that need to be answered. There are some states that have actually made these do-it-yourself kits even more heavily regulated, and we think it's better to have a more thoughtful conversation, and that's why this is uncodified language.
Okay, thank you very
much. Next, I see Delegate Valentine.
Thank you, Madam Chair. And yes, my question ties in with the self-administered kits as well. And I guess Ms. Jordan would be the best to answer this. Is this a new phenomenon? I'm not familiar with self-administered tests in my years in law enforcement. I've never heard of this terminology or these kits.
Yeah, it is relatively new, and they really have been coming to the forefront. I want to say within the past 3 or 4 years, they've been developed, and they're being heavily advertised by some commercial entities on college campuses. And again, people are really very worried that rape survivors are being misled, that this is going to be more useful than it is. But we also don't want to let the evidence go. So now, across the country, we're dealing with this.
Now, are these taking the place? I know before you could have like a Jane Doe kit where you would just be put down as a Jane Doe. Is this taking its place, or is that process still taking place?
You know, the Jane Doe kit, which for those of you who don't know, that's the ability to get a safe exam
Mhm.
without involving law enforcement. That is absolutely still happening. It's still required by federal law. It still happens in Maryland. This is for someone who doesn't want to even go to the hospital or involve medical personnel.
Okay, thank you.
Are there any additional questions? Okay. All right, well, we have a motion and a second to move favorable on the amendment that's been proposed. And if there are no further questions, we'll just do a vote. And so for those who are in favor of the amendment, you can just raise your actual hand or virtual hand, whichever you prefer. All right, I see 1, 2, 3, 4, 5, 6, 7, 8, 9 in favor. Anyone against? Okay, so Conway, you're against
Yes,
the amendment?
yes.
Okay. All right. So it was,
And can I explain my vote?
sure, absolutely.
I don't understand why a person would get a self-administered sexual rape kit and not have law enforcement involved in the situation. I just can't make the correlation between the two. Maybe Ms. Jordan may explain it a little bit better to me, but at this point I can't understand.
Sure, if Ms. Jordan, I don't know if you have an answer for that or anyone else here. I mean, I know for some individuals, you know, being sexually assaulted or raped is a very traumatic situation for most individuals who have undergone that. And honestly, there's a sense for some individuals, a sense of shame and embarrassment by it, which is partially part of the reason why a lot of these cases, one, go unreported, just in general, because there's that feeling that you have. Also, it just also depends on who the perpetrator is, especially if it's someone who's really close to you, your husband, your partner, or something along those lines. If you're in a domestic violence situation, you're afraid of, you know, that individual engaging in some type of retaliatory action against you or additional abuse against you if you go and report it. But yet you still may want to know kind of what the kit may result or show, you know. I mean, that's just from, you know, my understanding, my experience, what I've
Madam
heard.
Chair.
I don't know if anyone else wants to
Chair,
chime.
that's exactly what I'm saying. What is the kit going to show? I mean, is the kit like a birth control kit that's going to show that you're pregnant? You said you might be interested in knowing what the kit is going to show, and you know that you were sexually violated. You know you have evidence from the other person's DNA in you or on you. So what is the kit going to show if you're not going to turn it in?
So Delegate Conaway, thank you, Delegate Williams. That was an excellent description of some of the myriad of reasons that survivors might not want to go to the hospital or talk to someone. And you're right, Delegate Conaway, without further analysis, it's really just holding on to evidence the same way someone might hold on to, you know, any sort of evidence, a weapon or anything else involved in a violent crime. The only additional information I'd provide to the subcommittee is that unfortunately, we really do not have enough sexual assault forensic examiners in the state of Maryland. So recently, we actually had a survivor who had to go to 4 different hospitals prior to being able to get an exam. So I think that there really is a deficit in our resources available to survivors. And so some survivors, I think, are resorting to do-it-yourself kits because they don't want to go to 4 different hospitals, or they don't want to leave, you know, their home county or something like that. So we have a lot of work to do there. These do-it-yourself kits are a recent phenomena. We're trying to just keep things stable while we figure out the best policy and prevent evidence from being destroyed.
Well, I understand that, but I thought it was said that the kit might not be turned into law enforcement at all. So what is the need for the kit? Why would you take the kit and use it if you're not going to turn it in? I mean, I don't think that's the same as a person trying to go to 3 or 4 different hospitals and then turn evidence in. This is somebody that has the kit takes the evidence, has someone's DNA, and puts it on the shelf, I mean, for a period of time, rather than getting in touch with law enforcement, you know, maybe later than sooner, but at least going through that type of time.
Delegate Munoz, I see your hand. I don't know if you wanted to respond or if you had a question.
I just wanted to share, Chair Williams, Delegate Conway, with my background in mental health and then now law, and you being an attorney, I'm sure you're aware that a lot of times victims will report crimes, and then when it comes time to prosecute them, they are no longer comfortable or willing to testify. And so many of our criminal cases end like that. And so I think, in this situation, when someone, a man or a woman, an adult or a child has been raped or sexually assaulted, if they have the ability to take that evidence and set it aside, and then perhaps, reach out for mental health services, law enforcement services, advocate services to determine, what their best course of action is, and then, decide how they feel. Is it like someone said earlier, is this a father, a mother, a brother, a coach? Is this someone that, they're going to really struggle with, coming forward? And I think a lot of victims of a lot of different crimes, just are afraid, honestly, to pursue it. So that's all I wanted to share.
Yes, thank you. In response to that, I have a problem with this collection because you could have people that might not.
Oops. Oh, we lost you there, Delegate Conway. I think you accidentally muted yourself. I'm sorry, we missed the last thing you were saying, Delegate Conway.
Yeah, I have a problem with the potential that certain people can lie based on their emotional disposition. And we recently had some people in very high positions. I hate to use gun trace task force, but people who lied on stand and said this, that, and the other thing happened, and it didn't. So if you have people that are considered to be of a high caliber, you could have people that are emotionally scarred for other reasons. They use this as a tool. I'm just thinking that law enforcement or a hospital needs to be involved in this process.
Right.
That's just my opinion.
Right, but the kid is turned over to the authorities, the self.
No. Ms. Jordan explained that the kid might not be turned over to the.
Well, that's true. And if it's not turned over, then I don't see how a prosecutor can probably easily move forward with the case if the kid's not turned over. So there's that piece, Delegate Conway. I mean, the kid is to help the prosecution be able to make their case.
Okay, so therefore you're saying any person is allowed just to collect your DNA without your knowledge and wait on the potential of whether or not they decide to use it and what they're going to say. Is that what you're saying?
I wouldn't say without their,
so you could have, since you're an adult, you can have interaction with someone and don't know that they're going to do a Bill Clinton on you and collect your DNA, keep stuff on their dress and all of it, and then come back later on and say whatever they want to say.
Got it.
That's just my my opinion.
Okay. Well, we have a bunch of hands raised. So let's start with Delegate Simpson, then we'll go to Delegate Phillips and then Delegate Valentine.
I can think of many reasons that somebody would do a home kit. I'm sure on colleges it might not. It might even be more common to be there. And I think it also, just to piggyback on what Delegate Munoz said, I think it also could depend on who the perpetrator is, who the individual is, what their lifestyle is. Not everybody feels comfortable going to a hospital or someplace else. Not every place in Maryland is super, is in the city. Some of these places are very rural. So I can think of a whole host of reasons. I can also think of a lot of reasons that individuals might go through this and need some time to decide whether or not they actually want it processed, or even if they turned it in right away, to try to decide where they want to go from there. The assault is one thing. I think the entire process of reporting is its own traumatic, timeline.
And I do have a question, but I'll let Delegate Phillips.
Thank you. I think this is a question for Ms. Jordan, and I think I know the answer, but I want to make sure there's some clarity. With this bill, as it relates to what I will call the at-home kit, I don't believe this bill increases the probative value or the weight of the collection of this sample. So people can collect the sample and they're doing it today, but are we in any way changing the probative value that the at-home kits provide?
Thank you, Delegate. We are not. All we're doing is saying that law enforcement, if they get that kit, they're not permitted to throw it away. That's it.
Okay, that's what I'm saying. So to Delegate Conaway, I don't think this is not adding or taking away anything as it relates to the kits, right? So even if they didn't throw it away, the person could keep it, and 5 years from now could come back and still make the argument that they collected the kit at a certain time and that they were raped or inappropriately, something inappropriate happened between another person. So I don't think we're doing anything to add any additional weight or value to the collection of the data.
But respectfully speaking, I think you are doing something different to the collection of data, because just because a person says the data was collected on a certain day at a certain time, that doesn't necessarily mean that it's actually accurate. And I think once you have hospitals involved with it or law enforcement involved in it in a timely manner, that it was accurate, and the person who is being accused, they might be able to recollect what happened. And they might say, in that situation, I don't remember them telling me to stop. And I know that no means no, and therefore they collected this data. I didn't hear that.
Mm-hmm.
So there's a lot of ins and outs, but the committee has voted, and I appreciate you bringing that to. Thank you.
All right, thank you, Delegate Conway. Delegate Simpson, did you have anything else? Your little virtual hand was still raised. It's okay. And Delegate Valentine, I saw your virtual hand earlier, but I saw you put it down.
I believe my question was answered, but mine was with the home kits as far as the chain of custody and a lot of other things that it's just not gathered a certain way. But if it's just that the data or the kit has to be accepted if turned in, if that's the only part of this, is my understanding? If it's
Yep.
submitted to law enforcement, they have to accept it and have to retain it?
That's my understanding as well.
Okay.
It just has to do with the retention of it. Okay. All right, so the amendment passes. Like I said, we had 9 for the amendment and 1 against. And then let's just do a motion on the bill, and if there's further discussion, we can do that. So is there a motion to move favorable on the bill?
I would like to move favorable on the bill.
Okay, thank you. And Delegate
with amendments.
With the amendments.
I'll second with amendments.
Okay, it's been properly moved and seconded to move favorable with the bill as amended. Is there any additional discussion? I saw Delegate Schmidt, you had your hand up, but now it's the virtual hand is gone away.
I'm favorable with amendments.
Okay. All right, any further questions or discussion?
We need to add that hand for raising, for the judiciary Zooms.
Exactly. Okay. Well, then if there's no further discussion, do we have to do a roll call, Lauren, or do just a raise of hands for the favorable with amendments?
I'm sort of just your guest counsel, so I don't know what you typically do, but in our family law subcommittee, we do a roll call on them.
Okay.
So I think it wouldn't hurt.
It wouldn't hurt. Okay, well, let's just do a roll call just for to be extra careful. So I'm just gonna go in alphabetical order. So first up, I have Delegate Conway. Are you in? The motion is to move favorable with the bill as amended.
No.
Okay. Delegate Crutchfield.
Yes, move favorably.
Okay. Delegate Munoz.
Yes.
Delegate Pastor.
Yes.
Delegate Phillips.
Yes.
Delegate Schmidt.
Yes.
Delegate Simpson.
Yes.
Delegate Taylor. Was that a yes?
Yes.
Okay. Delegate Tolles.
Yes.
Delegate Tomlinson.
Yes.
Delegate Valentine.
Yes.
And the chair votes aye. Okay. All right. Well, thank you guys very much. All right. So that takes care of one down, 3 more to go. Bill 758. We will now move on to flip 759. And this is with regards to the Governor's Office of Crime Prevention, Youth and Victim Services, Sexual Assault Evidence Collection Kit reporting program. And then Lauren, I don't think we have any amendments on this one, if I remember correctly.
That's right, we don't.
Okay. And then can you just do like just a quick overview of the bill?
Yes, so it requires the Governor's Office of Crime Prevention, Youth and Victim Services to establish and administer a reporting program for tracking the location, status, and chain of custody of sexual assault evidence collection kits. Related requirements are also established for law enforcement agencies and others that have control or possession of these kits. The Governor's Office also has to adopt regulations relating to the reporting program. And the bill clarifies that the existing rape kit testing grant fund may be used for equipment, supplies, personnel, and outsourcing necessary for the testing of kits collected before or after the establishment of the fund.
Okay, thank you. Are there any questions for council? Seeing none. And if folks were here on just the first bill on 758, but you're not here for this bill, you're free to leave. So, but we do have 2 other bills still left to get to. All right, we'll see. There is a hand, Delegate Simpson.
Has there been any change or has there been any more clarification regarding the fiscal note to this? Or any other ways that we can get this paid for?
I haven't seen a new fiscal note on this one. Let me see what the fiscal note is on this. Looks like it costs.
I mean, it doesn't look like too bad. It's not.
Yeah, it's $119,000.
Yeah.
And that's for fiscal year 2024 for staff. Future years reflect an annualization and ongoing costs, but there's no cost to procure the reporting system because that is already in the process. What used to be GoCap is already in the process of procuring such a system. Regardless, they were planning on doing this regardless of this bill. So there aren't any additional costs as it related to acquiring the system. The cost is just solely, it looks like, for the staff, which starts at $119,000 and goes up to $167 for fiscal year 2028, which I suspect is probably salary plus benefits, is what it looks like.
Okay.
So, and I know people are concerned about our revenues, but I think this might be manageable. I think we can afford this. So. All right. Well, without seeing any other additional questions, I'll entertain a motion to move favorable.
I move favorable.
All right. Is there a
Second.
Second.
Okay. All right. And just again, just to be on the safe side, I'll do another roll call vote unless there's any additional discussion. Okay. Seeing none. Delegate Conway,
Yes.
Delegate Crutchfield,
Yes.
okay. Delegate Munoz,
Yes.
Delegate Pastor,
Yes.
Delegate Phillips,
Yes.
Delegate Schmidt. Oh, did we lose Delegate Schmidt? I think we lost him somewhere along the way. Okay, we'll skip him for right now. Delegate Simpson,
Yes.
Delegate Taylor,
Yes.
Delegate Tolles,
Yeah.
Delegate Tomlinson,
Yes.
Delegate Valentine.
Yes.
Okay, and chair votes aye. Okay, all right, so that is 7:59. So thank you so much, Ms. Jordan and Ms. Krinky, and others who were here for those two bills. We really appreciate you guys coming by. Next, we will move on to House Bill 582. Okay, and Bill 582, this is from Delegates Cardin. This has to do, and this is a public safety bill, has to do with the police accountability, time limit for filing administrative charges. And I think I saw Ms. Mansfield here for this bill as well. I think Mr. Spencer is also here. Oh, and there's Mike Davey as well on this bill. So I don't know if folks have any questions for any of those individuals for 582 or not. Okay, and we did hear, I mean, the bill hearing, I think was pretty straightforward. The one thing though, I guess, you know, a lot of folks, I know we have a lot of new members to our committee, but for those of us who were here, I guess about 2 years ago or so, I know Delegate Crutchfield was here when we were dealing with police reform. And we spent a lot of time working on that police reform legislation. And really it was a combination of a lot of different things that have been percolating here in the General Assembly for years, but then obviously in light of a lot of the, during the pandemic with the killing of George Floyd and a lot of the other social arrests, things going on that we saw, we passed the various measures dealing with police reform. And part of that also dealt with establishing these charging committees. And so I don't know, folks. Yes, Delegate Munoz, I see you have your hand up.
Thank you, Madam Chair. I am currently at my other job, and so I was wondering if someone could let me know what the testimony was from like the Maryland State Police or the FOP. Did any of our police officer organizations weigh in on this?
Yeah, I believe so. And I know we have Mike Davey, who's the attorney for the state FOP. If you want to comment, Mr. Davey.
Sure. Thank you very much, Delegate. So this bill is kind of a follow-up to what is currently in the law as it pertains to complaints that go before the Administrative Charging Committee. Those are the complaints that involve the public. And already in the law, there is a 1 year and 1 day statute of limitations from the date that the complaint is made to the Police Accountability Board for them to bring administrative charges against the officer. However, the Police Accountability Board is silent as it pertains to those other series of complaints that are made internally that don't affect the public. Internal complaints from neglect or something that doesn't affect the public. There is no statute of limitations at this time. So basically this bill would put a 1 year and 1 day statute of limitations from the date that the complaint comes to the attention of the appropriate law enforcement official. And then there were some amendments made to include there would be an exemption to the statute of limitations for those complaints that would involve criminal activity.
Thank you.
I see. Thank you so much.
Thank you. I don't have the amendments directly in front of me, but I know that there was also a letter, and I don't see anyone here from the Maryland, let me pull this back up here, from the Maryland State Police. And I think we had sent an invitation to them, but I don't know if they were able. Is there anyone in the waiting room, Brianna, by chance, in the Maryland State Police?
There isn't.
Okay.
Delegate, I mean, I've spoken to the attorney who represents the Maryland Troopers Association, and they're not opposed to this bill. As it pertains to the state police itself, I can't speak.
Yeah, because I know the state police did submit a letter in opposition to the bill.
Yeah.
And so and I don't know if folks had a chance to read it. It's on the floor system. But basically, and this kind of goes back to a little bit of what we were talking about earlier about just kind of all the changes that we did several years ago. And so, you know, their whole thing is once LEOBRA was repealed, and for folks who don't know what LEOBRA is, that was the Law Enforcement Officers Bill of Rights. And so with the police reform measures that were done several years ago, we repealed the Law Enforcement Officers Bill of Rights. And this was one of the things in LEOBRA that was you know, this is one of the things that was in LEOBRA, which we repealed. So, you know, I think the concern the state police has is that basically they're, you know, stating that LEOBRA was repealed, so was the statute of limitations, and that this language was originally in LEOBRA, and now this bill creates a new standard that may be hard to meet and force agencies to keep dishonest officers. That's a direct quote from the letter from the mail.
If I can respond to that.
Sure.
I mean, there already is a statute in the Police Accountability Act for those involving the public. You know, the idea of having a statute of limitations is for, you know, to ensure that these cases are handled in a timely manner and they don't go on forever. Discipline is designed not to punish somebody, but just to correct behavior. And if you have 2, 3, 4 years to discipline somebody for an internal matter, you haven't done anything to correct the behavior. It just doesn't make any sense. And this bill is simply nothing but a continuation to ensure that there's a statute of limitations on all cases of misconduct, which can move forward in a timely manner.
Mm-hmm.
And Madam Chair, if it's okay for me to comment, Andrea Mansfield representing the chiefs and sheriffs. And actually, the chiefs and sheriffs with the amendments on the bill, the chiefs and sheriffs are in support. We worked closely with the FOP as well as the sponsor on this. As introduced, we did have the concern because the language, it tied back to the date of the incident, not the date at the point in time that the agency was made aware of the complaints being filed. And then the additional amendment, or the addition of subsection E in the bill addresses issues where there may be criminal charges because currently the criminal charges need to be adjudicated in some format. Either they go forward, either they're dropped or so forth. We needed to make sure, and the administrative charges don't start until that criminal part of the process is completed. So we wanted to be sure the time frame allowed for that. So the amendments address both of those situations. So the chiefs and sheriffs are in support.
Okay. All right. So I don't know, Delegate Munoz, if you had a subsequent question. I just saw your virtual hand was still up.
My apologies, I have to put it down, but thank you everyone for the very thorough explanation.
All right, no worries. And then we'll go to Delegate Valentine and Delegate Crutchfield.
Thank you, Madam Chair. And I just wanted to reiterate and maybe clarify with what Mr. Davey had to say. When it comes to an administrative charge or an administrative inquiry, and I'm going to defer to him, maybe this might be something like missing cord or having a departmental collision or something administratively that does not impact the public. And I think the officer's fear is that this allegation or this misconduct will be held over their head indefinitely and will not be adjudicated. Or in 1 year and a day from the time the agency is aware of it is more than ample time to complete that investigation and get it resolved. That's what I see. Having worked under LEOBRA and having done those cases, it's not an ask to get this done within a year.
Mm-hmm.
You're 100% correct. That's exactly it's coming in late, working, missing court, having a departmental accident, not being prepared for work, things that are handled internally that don't affect or have any impact on the public at all.
Unless you have anything else, Delegate Valentine?
No, I would just say that, again, that does correct the behavior. By doing that rapidly, it corrects the behavior and you can move on.
Mm-hmm. Okay.
That's all I wanted to add.
Okay. Delegate Crutchfield.
Okay, I'm here in the House office building. It seems
I know we're all having internet problems here in the House. Yeah, I know. My thing.
So my concern is opposite of my concern is the opposite of Delegate Valentine's and the FOP, and that is that I'm just wondering why we have a limitation on time right now for these administrative charges to be brought. Because I know, I don't practice in this area anymore. But I know just doing general investigations and having charges brought, sometimes it takes a period of time before something is brought forward and that you actually are able to truly and thoroughly investigate it. So I'm just a little bit concerned about having some guardrails right now around this, especially since the police report.
Oh, I think we just lost you there, Delegate Crutchfield. At the end.
Anyway, so that's probably more thoughts than a question.
Okay, I'm sorry, we missed the last piece that you were saying here, Delegate Crutchfield. I apologize.
Sorry. Yeah, I was just saying that, I guess my concern is just putting guardrails around things right now. And we just passed police reform legislation a couple of years ago. I'd rather see how it's going with the ACCs and everything else, and then maybe circle back and do this kind of legislation, once we've had some data, something around it to indicate there's a problem. But right now, I have some concerns about, creating legislation around this at this point in time. So like I said, mine is more probably just thoughts and comments than a question. So isn't it so?
Okay. Thank you, Delegate Crutchfield. And Claire, I don't know if you have the amendment. For some reason, I don't have the amendment with my package here.
There's two sets of amendments, I believe, that Delegate Cardin submitted. Is he on this? Is he present?
See him.
Okay, well, there's actually 4 amendments from him, but I believe it's 2 sets of amendments. 793020/1 and 273328/1. And so let's see.
It should be a D, adding a D and an E.
So 7930/1. There's already a subsection D in the bill as introduced, and this first amendment where it says 1 year and 1 day from the date of the incident, it inserts 1 year and 1 day from the date that the law enforcement agency is made aware of the incident.
Mm-hmm. Okay.
That's one of the amendments.
Okay.
And then the other one, 273, adds a subsection E that says, so it adds on to subsection D, except as provided in subsection E of this section. And then subsection E says, if alleged police officer misconduct is related to activity that reasonably appears to be the subject of a criminal investigation, an administrative charging committee or law enforcement agency shall file any administrative charges within 1 year and 1 day from the date of 1, the investigating law enforcement agency's determination that the matter is not related to criminal activity. 2, the final.
Could you bring me an envelope?
Oh, you're not muted, Delegate Tomlinson, just FYI.
Oh, thanks.
No worries. We just know you need an envelope.
2, the final disposition of all related criminal charges, or 3, the administrative charging committee or law enforcement agency's receipt of notice that the appropriate prosecutorial authority declined to file criminal charges.
Okay. Okay. I see Delegate Simpson has her hand up, and then I have a question.
I would just like a little bit more clarification, I guess, because the bill doesn't specifically explain what the administrative charges. I want to make sure that we are really all in agreement of what exactly falls into that bucket before we move forward with it?
Yeah,
Does
I
that
think
make
that's one of my
sense? I
questions
just,
I have too. I mean, I know they were talk about use of a vehicle and things like that, but would that also include, I mean, and I'm just going to take the green case just because it's in, from Prince George's County and it's something I'm just familiar with, with that situation. I mean, obviously there were the regular criminal charges that were brought against the officer, but I'm sure there was some administrative action that was also taken against the officer in that particular case. And so would that also fall under this bucket and category within
It
the
would
1
be
year
part of
day?
E, it would be part of E, which was the exception of any statute of limitations at all. So in a case where the officer is accused or being investigated for a criminal act, there is no statute of limitations whatsoever based on this bill. So they could be charged 1 year, 2 years, 3 years, administratively charged 5 years later. Whenever that case is adjudicated, they could be charged. So the exception for criminal activity is in the amended section E.
Okay.
So Delegate Simpson, I think if you look at what's already in the police reform, when we talk about an issue involving the public, they're already in the law as a 1 year and 1 day statute of limitations, because that goes to the Administrative Charging Committee. This bill is for those cases that don't go to the Administrative Charging Committee. They are internal because they don't involve the public. That would be for missing court, having a car accident, using derogatory language in the precinct, not involving the public. There's a lot of issues, and I find that probably 40% of the cases that I handle don't involve the public at all. They simply are internal complaints made by supervisors or other officers internally. And right now in the law, there is no statute of limitations on those cases. And we would just like to put the 1 year and 1 day consistent with those charges that go to an Administrative Charging Committee, just make it consistent. That way, all complaints are handled in the same or have the same statute of limitations per se.
I would just like to actually see, because I know that I just think of certain, and not just in this case, just times that folks in different types of occupations will say something is administrative, and that's not necessarily the same everywhere.
I think the law is pretty clear. If it involves the public, it's going to the Administrative Charging Committee. If the public's not involved at all, it stays in-house, and that's what we're trying to address here.
And I don't have the amendments. Mine stops at D, so I don't.
Yeah. So let's do this, because I don't have that second amendment or last amendment.
I mean, if I had it, I'd probably be there.
With the new E, I the first one, because I was aware of, myself, I know Ms. Mansfield, we talked about that one previously. So why don't we do this? We still have a little bit of time. Why don't we, and I'm sure we're going to have another subcommittee meeting this week. I have a funny feeling maybe Wednesday, if we can squeeze it in. So, or, sometime soon. So why don't we table this one so that everyone can get the most recent set of amendments. We can all kind of wrap our heads around that. The one question I do have, if this was not in place, what is the current statute of limitations right now?
For cases that involve the public, that go before the Administrative Charging Committee, it's 1 year and 1 date from the date they get the complaint.
Right, but for cases that does not go to the public,
there is no statute of limitations at all.
So there isn't like a default under the regular rules of a 3 year or something like that.
No, ma'am. It can be 1 year, 2 years, 5 years, 10 years.
Okay.
I'm sorry, Madam Chair, may I ask a question?
Sure, Delegate.
What would it have been prior to the abolishment of the Law Enforcement Officers Bill of Rights? What would
1 year, 1 year and 1 day from the date it comes to the appropriate law enforcement's attention. And then there was the exception for criminal activity, because those cases do take a longer amount of time to investigate, similar to the Green case that Delegate Williams talked about. So we have taken the position, we agree with the chiefs and the Sheriff's Association, that because those cases take much longer to investigate, there should not be a statute of limitations on those cases.
Okay.
All right. Okay, well, we're going to table this just so all the committee members can kind of get all of the amendments and we can all kind of wrap our heads around that and move forward with that. So we'll just do that for that one for right now. And then the
So
last,
Delegate Williams, so I will talk to Delegate Carden just to confirm what amendments he is putting forward.
okay,
I think it's those ones I described, but I just want to confirm that with him.
okay.
And then I'll try to combine them into one and make a reprint.
Oh, that would
and
be great.
Send them to your assistant and then she can send it out to everybody.
Okay. All right. That sounds great. Okay. All right. And then the next bill that we have, we're moving faster than I had thought here, is the last bill is 663. And I know hopefully my office sent to, I did talk to Delegate Carden a little bit earlier today on this bill. I've gotten some correspondence, which I believe was sent to all the subcommittee members from the ACLU with a number of concerns that they have with 663. And so hopefully all of the committee members got that email, received that. If you didn't, just let me know. We can get that to you, Roz. Okay. And they weren't, I know, was not able, she had mentioned in the email, she was not going to be able to make this subcommittee meeting, but which is why I wanted to make sure I forward that email out to everyone so you all would be aware of those concerns. Claire, do you want to give a, I guess, kind of one, are there any amendments to this bill, Claire, to 663?
I'm not aware of any.
Okay, I'm not aware of any amendments either. So can you just give us kind of a brief summary about this bill and what it does?
So it authorizes a police officer who is denied a right granted by laws relating to police accountability and discipline to apply at any time before a hearing is held by a hearing board to the circuit court for an order that directs the law enforcement agency to show cause why the right should not be granted.
All right. And all right, so that's the summary of the bill. And I don't know if folks have questions or for those who are here. Like I said, unfortunately, the ACLU wasn't able to be here, which is why I wanted to make sure you guys got their comments. Okay, yes, Delegate Conway.
Just for the record, Madam Chair, what did the ACL do? What was their position?
Oh, they're against the bill. I mean, that's the short version of it. I can give you the more longer version.
No, I don't need it personally. I can read.
Oh, okay. But yeah, the first paragraph says they're in strong opposition to the bill.
Thank you very
and
much.
I think part of it is related to what we were talking about earlier with a lot of the work that was done a couple of years ago around the police reform bill. And so they have concerns that this is, somewhat of an attempt to kind of to put back into statute some of the provisions that were part of LEOBRA that was repealed several years ago with regards to this bill. I'm just kind of paraphrasing the letter because it's pretty long, but that's kind of the gist that I got from the letter. And so Delegate Simpson, I see you have your hand up.
Yes, I turn my video off at the same time, turn my thing on. So I just have a bunch of question marks in my little, I think what was missing is, I don't know that I understand this. So can somebody give me the story of how this is going to work?
If I may.
Yes, please.
Yeah.
Sure.
No, I'm looking at my notes. I'm going, oh, it just says question big.
So first of all, this only applies to one section in the entire Police Accountability Act. It's 3106, and it's the trial board and how they work. So how this would work is if as we're preparing for a trial, we go through 103, 106 and see that the agency didn't do something they're required to under the law. Just in that section, the officer has a right to file what's called a complaint for show cause in the circuit court. And the way it was written was consistent with the appeal process. If it's a state agency, it would go to the circuit court in Annapolis. If it's a local jurisdiction, not a state agency, it would go in their local or their jurisdiction's circuit court. And what it would do is you'd write a complaint and basically say, we believe this right was not followed. That's required under the law. It would go to the circuit court, and a circuit court judge would then order the department to write a memorandum and say why the right was not afforded or it didn't have to be afforded. Generally, after that, there's a hearing, and the judge will then make a determination. Yes, the right was violated and what the remedy would be, or no, the right wasn't violated. You go to a trial board. This would also require us to file that show cause prior to the trial board even beginning.
Delegate Simpson, if I may piggyback on that.
I was going to say, just get a little bit more specific. Tell me specifically what would they have violated? Just give me a scenario that you really know of.
3106, if they don't set up the trial board in the manner in which they were supposed to, meaning who's on the trial board. They don't give the required training that was required for a member to sit on the trial board. They don't issue the subpoenas that were requested that they're required to under the current law. It's honestly not a lot. It's just those certain issues because it's restricted straight to 3106. It's not the entire Police Accountability Act.
So, Delegate, we don't read it the same way as Mr. Davey does. The way the bill is written, by the way, say I'm Jerome Spencer. I'm the General Counsel of the Charles County Sheriff's Office. I handle discipline matters for our agency. I'm also here on behalf of the Chiefs and Sheriffs Association. And as I said when I was before you guys live, we're not opposed to the bill as such. We want to make sure you understand what the ramifications of it are. As I said at that hearing, obviously we want all of our officers to have full due process. The bill is currently written says that anytime before a hearing under 3-106, a police officer denied a right granted by this subtitle may apply to the circuit court for an order that directs the law enforcement agency to show cause why the right should not be granted. I didn't go back and compare the LEOBR language, but it's pretty darn close to the LEOBR language. So it applies to way beyond a potential hearing before a hearing board. And going back through what the LEOBR had, I spent the weekend going through every case that mentioned show cause in LEOBR. And there are multiple reasons why the show cause was filed under the LEOBR. Included, I was being denied my right to have secondary employment, for example, which had nothing to do with discipline. In one case, Montgomery County FOP was upset that the Montgomery County Police Department wanted to start videotaping interrogations of their officers. So there are all kinds of reasons why show cause order could be filed with the circuit court. And there are going to be a lot of issues come up under the entire subtitle that are going to be new issues. We're working through a new process, but it's not. As I read the bill, as we read the bill, it's not limited to just an issue with the trial board that's been picked. It's going to be going forward. And it can occur anytime before the hearing board takes place. It could be the day before. There was a case with the LEBR where it was the trial board actually started and they hadn't quite taken testimony yet. And show cause order was filed and the case got delayed for quite a long time.
Okay.
So I just reread the portion under 3113.1A, and I believe Mr. Spencer is correct. The most important thing, there's been a former case on the LEOBR based on a show cause. And the circuit court, actually the Court of Special Appeals, ruled that this does not prevent the trial boards from going forward. The mere fact that an officer or his attorney files a show cause doesn't mean the trial board has to stop and they have to wait. What it basically says is if the department decides to go forward, they put themselves in peril of having to do the trial board again. So it's not an automatic stay. It doesn't block the department from going forward for a trial board. They may or they may not. The complaint could ask for a stay. It may or it may not. But it basically protects the rights. What we're trying to do with the show cause is get before a circuit court judge before there's a negative action in the trial board. Then we have to appeal it and then go to the circuit court at that time. We're just simply trying to get out in front of it.
Is
And then
something maybe
case-
we need to hash out a little bit better or no? Is everybody comfortable with it? So far?
Well, I had a question and we'll go to the two hands and I do have some concerns, but my question I have, so the case you were citing, Mr. Davey, what year is that case from?
Sure, that was 2001, I believe. It's Mass Transit Administration versus Hayden.
Okay,
It
so that
was
was
a-
before we did the repeal though.
Yes,
So there
that's
hasn't-
correct.
So there hasn't been any case law interpreting this since the police reform legislation's been enacted.
We haven't had one case come before any trial board in the state of Maryland yet under the new law.
Okay, all right, so maybe this might be a little premature, but I'll go to Delegate Taylor and then Delegate Conway.
Thank you, Madam Chair. This should be an easy question, and maybe it's just me not being familiar. I'm looking at the Maryland Judiciary opposition letter, and even though we already mentioned that the trial board decisions would have to be taken up in the circuit court in the locality, but why do they mention Anne Arundel County only? Like, why is that a
Sure.
mistake, or does the amendment address that?
So the Police Accountability Act, as it pertains to discipline, if you lose in a trial board and you want to appeal it, the law is already written that an appeal from an officer in a bi-county agency or the state must appeal in the circuit court for Anne Arundel County. So that's already in the law. If it's a local jurisdiction, it goes to the jurisdiction in which the officer is employed. So what we did is we just took the same language for an appeal and put it into the show cause request.
Okay. What was I about to say? Okay, sorry, I just got distracted. Point I just realized before we move, I see your hand, Delegate Conway. I just realized for my non-lawyers, I have to remind myself to try to explain lawyerly terms for my non-lawyer friends. So I don't know, Claire, if you want to explain kind of what a show cause is, because I just realized it's like a little legal term of art there.
And maybe somebody like Mr. Davey who has experience with this kind of thing.
Yeah.
can give a better
Sure.
answer, but
Sure.
So a show
Maybe that
cause
might
is
help.
basic, it's a complaint that you file in the circuit court if you believe one of your rights under this section is violated. So you would write a memorandum to the court, or you write a complaint, basically saying this is the right that was violated. The circuit court then takes that complaint, sends it to the agency involved, and says, this is the complaint. You have to respond, show cause to the court why that right was not afforded to the law enforcement officer. Memorandums are drafted. Most of the time there's a court hearing, and then the judge determines whether the right was violated or not. I mean, that's probably the most generic way to explain it.
Okay. All right. Thank you, Mr. Davey. Delegate Conway.
Thank you, Madam Chair. I was wondering if any of the witnesses would like to respond directly to the ACLU's opposition so that we could get.
I haven't seen the letter. I couldn't respond.
We have not seen it either.
Thank you very much.
I will double check and make sure you're okay with sharing that, and so I can share that with you guys, and that's fine. I guess my concern I have with this is that I guess you mentioned, Mr. Davey, that we haven't had any situations where this has come up yet since we've enacted this legislation. And I know, we still have counties that are still trying to get their charging committees together and get everything situated and organized to form it, to get into compliance with the law that just was recently enacted. And so my worry that I have, and I definitely understand the FOP's concern, is that I think it's just a little premature right now. Because we're just trying to get our feet wet. I mean, get our sea legs underneath of all of us as it relates to this new legislation. That's I think kind of the worry here right now with this. So, but let's do this. I hate to table one more thing because I know time is of the essence. Let me try to get to you guys the ACLU's remarks so you can have that and take a look at that. And then I will work with council in trying to find a good time and date that doesn't conflict with any of the other subcommittees that are coming up this week, for us to maybe revisit these two bills.
So
if
Della,
that
can I leave you with this? Can I leave you with this thought? What your questions that you said there. It's certainly true that this, House Bill 670 gave us a new landscape. And it's certainly true that even when the LEOBR have been around for 40 years, and there's still situations where show cause were followed and there's merit to them. So the fact that there are issues, even after 40-year experience, doesn't mean there's not gonna be issues with this. I think ultimately the policy decision before you as a legislators decide what is going to be an appropriate way for an officer to raise, and there will definitely be legitimate issues and concerns on behalf of the officer. Under the LOBR, the officer had two choices. He could file a show cause order with the circuit court and get a ruling. Ms. Davey is correct that technically under the Hayden case, the trial board could still have gone forward, at least in one situation where the trial board did, it was to decorate the agency. And as I mentioned to you guys, I would never tell my agency to go forward waiting for that. Or option number one probably is the officer allowed to file show cause and get ahead, as Mr. Davis said, ahead of the issue. Option number two, which is true for the vast majority of administrative proceedings, go through the hearing, raise issues for the hearing board, and then there's an appeal to circuit court after the fact. So even if the body to do nothing with this order, an officer is going to have the due process of complaining to the circuit court after the hearing that there was an issue. And ultimately, that's the policy that has come on you guys to make, is that we're going to give the officer the opportunity to, and one of the things we want to communicate to you on behalf of the agencies is it will delay the discipline. It's going to put a pause on it. Just,
okay.
It's a practical matter. It has to. I think it's too risky to go forward on a hearing without that rule from circuit court. We're allowed to occur afterwards. That's fun. I think that's fundamentally the policies you have in front of you on that.
Okay. All right. Thank you, Mr. Spencer, for that. Delegate Conway, I see your hand.
Thank you, Madam Chair. So, Mr. Spencer, are you saying that you're prepared to move forward without seeing the objections from the ACLU?
I don't know that anything the ACLU has to say would impact our position in filling the bill. Fundamentally, I know this came up during the debates on the whole police form issue. Fundamentally, this is an employment issue. This is an officer has broken the agency's rules. This is not the civil lawsuit. This is not a criminal prosecution. And so I don't know that the ACLU, I mean, I shouldn't sound so dismissive of them, but from the agency's perspective, we want to know what the rules are. We're going to make sure the rules are followed and give our officers a due process that they're entitled to within the law and the Constitution. So I don't know that anything the ACLU says is going to change the information we're going to give you.
Mm-hmm.
Okay, thank you, Mr. Davies. You feel the same way?
Like I said, I haven't seen the letter. Based on what Delegate Williams stated very briefly, that one of their issues is that we're trying to change the Police Accountability Act before we even had it going, but in the same breath,
Well, that
other...
part was me. That part was
okay.
Me.
I apologize. Yes, I haven't seen the letter, so I can't comment.
And
I'd have to see the letter.
I didn't chime in on the chair because I don't think you had time partly because of the COVID virus.
That's a good point. That's a good point, Delegate Conway. I know things did get delayed because of COVID a little bit as well. I guess one of my other questions that I have, so with these investigations, and I guess, again, I'm thinking about my own county in Prince George's, and I know there was a lawsuit that was pending by some of the officers in Prince George's County against the police department, most notably a lot of the African-American and Latino officers against the county for racism internally within the department. And they have filed that suit against our county police department, alleging racism and things like that. Is that something where if this bill were to get enacted, a show cause could be filed to kind of delay that action in that type of situation?
No, ma'am. This would only apply to discipline. It would not have anything to do with an officer's right to bring a lawsuit or the department to bring something. This is purely a discipline-related issue.
Right, but what if the officer's allegation is that the reason that they're being disciplined is because of their race? And I guess one of the examples, one of the reasons they brought forth the lawsuit, that was one of, I think, the allegations was that they felt like the officers of color were being disciplined more often for certain things than, say, that some of the other police officers internally within the department.
I do not believe that a show cause would be the appropriate manner to address that issue. And I don't believe that's something, I can tell you in my 24 years, that's never been an issue I brought a show cause on. Because that would be handled in a civil matter as opposed to the disciplinary issue at that moment. You might be able to raise that in a preliminary motion, but I don't believe that is something that a show cause could address.
I agree.
Okay. All right. Okay. All right. Well, let's table this a little bit. Thank you, Mr. Davey and Ms. Mansfield, Mr. Spencer, for joining us this afternoon and answering our questions that we had around both of these bills. We'll get on the previous bill, we'll get the amendments out to all the committee members so they'll have them, and we'll try to also deal with the concerns that the ACLU have, which were plentiful, and see if there's a possibility of moving forward. So, okay.
Great. Thank you, delegates.
All right. So those are all the bills that we have on our agenda. I thought we were going to go to 5:30 and it's only 5:13. So I'm really happy about that. So we will please stay tuned, committee members, to your email, and also floor. We may have another subcommittee meeting again this week because we are approaching the crossover deadline. And so we'll be back in communication about our next meeting, which will probably definitely be before Monday. And with that being said, I'll entertain a motion to adjourn this meeting.
Motion to adjourn?
All right. Second.
Second.
All right. Thanks, everyone. All right. Have a great rest of your evening. I'll see you this evening on the floor. Thank you.